That was quite the story. But the problem is nothing in that story tells you what evidence they have, what evidence they're going to show. You know, how are they going to actually tie me into that story? Anyway, you know, the prosecution, you know, tells that story, but the problem is very little of that story is true. That's the bottom line. And, you know, yes, about the only thing that was true in that story is, yes, John Travis Johnson was there. We're going to, you know, put on the surviving victim, Miss Paula Bellamont, who says, 100% sure it wasn't me that night. 100%. Now, just as Mr. Alvarez said, you know, this is a woman who was brutally beaten, robbed, had her throat slit, you know, literally sat there and watched her friend get murdered viciously. But yet she is testifying on my side. Now, don't get me wrong, you know, what motivation could she have?
He's not a lawyer. Didn't even stay in a Holiday Inn Express last night. He's representing himself in a murder trial. Everything at stake. Franklin Ty Tucker. That's what he looked like in court. Let me show you what he looked like when he got arrested for this. Looked a little different back in the day when he got his picture taken by the Monroe County Sheriff's Office. Cleaned himself up, but obviously a smart guy, well-spoken, great poise in front of that jury in his opening statement. This is the Treehouse murder case that we're covering here on Court TV. It's really a deadly robbery, a tree home invasion kind of case where there's a robbery, there's a wheelman, two guys go in, somebody gets murdered, and prosecutors say he's one of the two murderers. But seems like he may have some good evidence on his side. Let's go into the courtroom and show you what happened today as he cross-examines an important witness, Deputy Danielle Malone, and then goes at it a little bit with the judge. Let's watch.
So there's two subjects that come out of the car, right?
Yes, sir.
This is, you know, apparently, because, you know, we can't see it, but apparently they came out of the truck. Okay. Okay, could you please pause it right here? Okay, we see two subjects. I would assume, I'm hoping the jury can see this. Again, is that what you describe as two subjects?
Yes, sir.
Okay. And could you describe who those subjects were based on what you see right here?
It would be Mr. Wilson and Mr. Tucker,
Okay, and how would you know that?
based on everything I know.
But not what's in the video. I'm asking you to
You gotta
testify.
let her finish her answer,
Sorry.
please. Anyway, did you finish your answer?
I know that it's them two people based on all the evidence that I knew at the time when I wrote my arrest affidavit.
And to be clear, did you write your arrest affidavit after seeing this video or before seeing this video? I'm
After seeing this video.
Okay. And you know that it's those two subjects based on not what's in the video. I'm asking you to testify exactly what's on the video right now, not what you learned from your investigation. What can you see in the video?
Two subjects walking to the trails.
Exactly. But you can't identify a single person in those videos. Correct?
Absent all knowledge of everything.
Absent your knowledge.
Yes, you can't see faces in the videos.
Okay, good. That's all I wanted to clarify. What other evidence did you have to say that I was in that video? You said it was based on your investigation, so.
Again, John Travis Johnson's confession.
So John Travis Johnson's word that it's me in that video.
Yes, sir.
Okay. And any other evidence that said I had anything to do with this prior to that video?
Mr. Rory Wilson again stating that you were part of the planning
Okay.
of the robbery of Paula Belmonte.
We'll take a look at that later. So at this point, you're taking Travis Johnson's story and Rory Wilson's story, correct? That's your evidence at this point.
In combination with Todd O'Quinn's statement of the way he went up to the CVS, yelling for the police, yes.
I don't understand, maybe it is the layman in me, and maybe you can educate me on this, how that look, it's the credibility of the investigation that is what is the evidence they're using against me in this trial. How is that not credible if the investigation was not conducted, on any kind of good standard.
It's not the credibility of the investigation, it's the credibility of the evidence. That's what's at issue. Like I said, if you can show that there's been a bit of evidence that's been tainted, if there's been a witness that's been compromised, but to say, oh, this was just an investigation that violated all these standards, no, sir, that's not relevant.
Well, I would imagine that, again, 208 pieces of evidence were mishandled. That was what was sustained in this investigation, including DNA, including video, including physical evidence. And yes, this is evidence that the prosecution is actually putting into evidence in this trial.
All right, Lori Murray, what do you think of the pro se murder defendant?
Oh, you're asking for hearsay, sir. Stop it. You know, he did a decent job in his opening statement. I will give him that. He is well-spoken, especially for somebody that, I think this was like a crack deal or something that they were arguing. Anyway, he did a decent job. But if what he said is true in his opening statement, then he's got some decent evidence on his side. And if he had a lawyer, he might actually win the case. But he's just messing it up. He's just blessed.
Ben Chu, what do you think of this? He's representing himself. I mean, he knows the case inside and out, and he knows the ultimate truth of whether or not he was involved. Is that an advantage or disadvantage?
I think it's not an advantage. I agree with Lori. The cliche is that a lawyer who represents himself has a fool for a client. I think it goes for anybody, especially in this situation. He doesn't have the expertise, number one. And number two, he's too close to it. I think it's a conceit that he can represent himself effectively, though he is, I agree, he's incredibly well-spoken.
Actually could do voiceovers, too, if you listen to his voice. But, Laura, let me ask you, Laura. His wife, who married him after this whole mess, who loves him, they were high school sweethearts, then they got married. She's got a lot of money. She's the co-founder of CrossFit. So if they want, I mean, she was able to post a $2 million bond to get him out, before the trial and during the course of the trial. They could probably hire they could probably even hire you. They might be able to afford you, Laura.
And they can always give me a call.
So what?
That's an interesting fact, Vinny. I have to admit, I had no idea that he had a wife who was so well off and affluent and could afford to hire a private counsel. So I'm not sure what is going on here. I'm not sure if he's setting it up, I don't know, for appeal, but something is not making sense to me, especially that if they've got the funds, it would have made total sense for him to have an attorney, whether it's a public defender or private counsel. The idea that he is defending himself on a murder charge is, I mean, that's daunting for an attorney who is a defendant. It could be daunting for any layperson. Yes, he was very impressive on the opening, but my goodness, when it came to asking questions and on cross, he wasn't doing so well. And it would be wise for him to hire an attorney even at this point. I don't think it's too late to do that now.
Yeah, I think the only slight advantage that is potential for a pro se defendant is that you spend a lot of time in front of the jury. Maybe they create some bond with you, but if they really hate you and you're annoying them, then it's a bigger problem. But if you have any sort of quality that's endearing, you don't even have to testify for the jury to get to know you. They'll get to know you from just the questioning and all of that. But yeah, at the end of the day, there's no way, folks, there's no way, if you're charged with any crime or even sued, that you should be representing yourself.